According to the Institute on Statelessness and Inclusion, there are an estimated 15 million stateless people across the globe. However, statelessness is not a very well-known topic. In this video, we will introduce the ways stateless people experience protection gaps in Canada and propose some recommendations for improvement. Under international law, a person is stateless when they are not considered a national by any state under the operation of its law. Individuals can become stateless when a country's bureaucratic practices create conditions where access to nationality is restricted. For example, parents are sometimes unable to or ineligible to access civil registration procedures, making it impossible to register their child's birth. As birth registration is often a prerequisite for granting nationality, lack of birth registration increases a child's risk of statelessness. In another example, denationalization occurs when a government revokes an individual's citizenship, typically due to activity deemed harmful to the state, leaving denationalized individuals at risk of statelessness if they do not possess the nationality of another state. Entire communities can also become stateless. For example, the redrawing of borders after conflict or secession can lead to the non-recognition of nationality. Prominent examples are the dissolution of the Soviet Union in 1991 and Yugoslavia in 1992, where millions of people were denationalized. Ethnic and minority groups are also discriminated against by states such as in Myanmar, the Dominican Republic, Bhutan, Kenya, and Madagascar. Discrimination along gender occurs in 25 countries where nationality laws discriminate against women who marry or who are born to foreigners, or simply because they are women. These women often cannot confer nationality to their children, meaning children whose fathers are missing, deceased, foreigners, or stateless themselves are at risk of statelessness. Indigenous people also face unique challenges in accessing nationality, leaving many at risk of statelessness. Registering birth can be complicated by migration, discrimination, and intergenerational lack of documentation. Indigenous nations often live fluidly on both sides of colonially imposed borders, and accordingly, they sometimes face bureaucratic challenges when accessing birth registration records across multiple jurisdictions. The number of stateless people in Canada is unknown. In addition to this problematic lack of data, there are also serious protection gaps in Canada's legislative framework. For example, Canada is not party to the 1954 Convention relating to the Status of Stateless Persons, which stipulates standards of protection that states are required to implement. The Canadian government argues that existing citizenship, immigration, and refugee laws provide sufficient pathways for the protection of stateless persons. For example, stateless persons can seek legal status in Canada through an application for permanent residence on humanitarian and compassionate grounds, an application for citizenship through ministerial discretion, or via the refugee determination system for those with a fear of persecution. However, this patchwork of laws and policies does not adequately protect stateless people in Canada. A particularly striking gap is the lack of a legal definition of statelessness itself. Canada includes stateless person in its definition of a foreign national, a counterintuitive approach to the unique condition of statelessness whereby one is not a national anywhere. Canada also does not have a specific process for statelessness determination, nor a stateless person status. These contradictions create challenges for stateless people in accessing social housing, public education, healthcare, social assistance, identity documents, travel documents, and naturalization. Stateless persons are also vulnerable to lengthy immigration detention while they await removal, which can induce several mental health challenges including hopelessness, suicidality, and addiction. Canada's citizenship legislation also risks imposing statelessness on individuals as it limits the ability of first-generation born-abroad parents to pass on Canadian citizenship to their children should they also be born abroad. This second-generation cutoff permanently denies the first-generation born abroad the right to automatically pass on their citizenship to their children born abroad, and leaves them with no legal mechanism to appeal this restriction, irrespective of their ties to Canada. To address these protection gaps, we propose 4 key recommendations. First, Canada should ratify the Convention on the Status of Stateless Persons. Second, Canada should recognize statelessness as a legal status. Third, a statelessness determination procedure would streamline Canada's response to statelessness and reduce any overlaps with Canada's refugee status determination procedures. Finally, we need more research and information on statelessness in Canada and globally.